Good day to everybody. Good afternoon or good morning if you're on the West Coast. I'm Lisa Bronner, and I'm going to be talking to you today about some things to be thinking about when you are planning to reopen, and flagging for you some potential legal risks with respect to the workplace, and things to think about and consider, and ways in which to mitigate risks. And at the end of the presentation, I also have some resources for you related to reopening the workplace and various guidance. So let's get started. So I would say, kind of at the outset, I'm coming to you here from New York, and I'm following the guidance that we are getting both from the CDC and OSHA, but also from our governor in New York State. And one of the things that he says, which is follow the data, follow the science. So be alert to what's happening, obviously around the country, but also in your jurisdiction in terms of what the conditions are on the ground there. And follow the Centers for Disease Control and OSHA, Occupational Safety and Health Administration, and your state and local guidance on how to reopen your workplace safely. I would say that to the extent that your state or local guidance is more employee protective in terms of minimizing legal risk, that's probably a good idea to heed that advice, and to designate a COVID-19 task force for your reopening. Find who are going to be the key people in your workplace that are going to help you formulate this plan for safely reopening. And to the extent that your governor has not talked about a phased or staged reopening, consider that may be a safe way to consider reopening. So the CDC has put together a one-page kind of checklist for determining when it's safe to reopen. And I wanted to go over some of those high points with you here to help guide you through your own process with your task force, if you have one. So CDC asks three major questions. The first one is, should you consider reopening? And to know the answer to that, your very first question is, well, what does our state and local order say? Of course, right? They have to permit us to be able to open. And are you ready to protect those employees who may be at higher risk for severe illness, and how are you going to address that? So both of those questions need to be answered first with respect to reopening, but there are two more questions that you need to consider. Have you put your recommended health and safety actions in place? Like I was saying, if you've got a task force to put that together, you want to have those systems in place, obviously, before you reopen. You want to know exactly what you're going to be doing, how you're going to be doing it. And I'm recommending that you have written plans for each of those things, for your safety protocols, for your cleaning and disinfecting protocols, for what your actual plan is going to be for how you're going to bring your workforce back. So sticking with this right now, your health and safety actions, the CDC has said promote healthy hygiene practices like hand washing and employees wearing a face covering. Intensify cleaning, disinfection and ventilation. We're going to get to questions I know people have about, well, what if my organization is a tenant in a building and we don't own the building? What should we do then? So we'll get to that as well. Encourage physical distancing, the CDC recommends, and enhance spacing between employees, including physical barriers. Think about things like the use of plexiglass, both at the entrance to your area where clients and the people that you serve may be coming in. So that area, as well as between employees, how you're going to separate them to maintain a safe physical distance of 6 feet. You may have to consider now ways in which you're going to reconfigure your workspace to allow for that. Continue to encourage teleworking to the extent that you can, to the extent that your employees are working productively and working well remotely, consider maintaining an option for as long as you can. Think about your communal spaces and think about highly trafficked areas in your workplace and plan for those. How are we going to maintain physical distancing in those places? In terms of the employees that you do decide to bring back, consider whether you want to stagger the times that they start. If you are in a large urban area, then your employees may have to deal with mass transit and large crowds, and may be concerned about that, about their own safety as they travel to work before they even get to the workplace. So one way to address that may be to stagger the start times or the end times of your employees, to think about perhaps staggering the days on which they come in, how many people you're going to have in the office at any one time, as well as staggering breaks throughout the day, lunch breaks. You're really going to want to think about, if your employees previously all sat together in a conference room or in a kitchen, eating lunch together at the same time, you're going to really want to think about modifications of that in terms of how many people are we going to have in the kitchen or in the conference room at any one time, and then limiting large events where that's feasible. Consider that at this time modifying any type of travel practices that you have, to the extent you have employees that are traveling for work, to limit or prohibit it for now until we know that that the situation is safe. And again, promote telework to the extent that you can. Think about commuting practices. You may have employees who say to you, I don't want to be traveling at rush hour, or are there alternatives? If there's a situation where you think that it's appropriate and feasible and financially doable to provide transportation in lieu of your employees taking mass transit, whether it's taking a black car or providing a private van service for employees or other alternatives, it's worth considering those now. And it's also really important that you're training your employees on the protocols that you plan to implement. In fact, discussing it with them before they come back into the workspace. Here's what we plan to do. And coming up with actually a plan for them, an easy to digest shorthand sheet of, here are the things that you need to know about when you come back to the workplace in these various areas. So the CDC says on the second component, on safety and health, if the answer to your question is no, then you need to meet the safeguards. You need to ensure that you have these safeguards met, that you've considered all these things, that you've made a plan, you're going to train your employees on what your protocols are, and you're going to take the necessary steps before you reopen your workplace. And the third component that the CDC has recommended that employers look at before reopening is, do you have monitoring in place? So do you have procedures in place to check for signs and symptoms? Are you planning to take temperatures of employees? Will you get one of the scanners where you can scan their temperatures every day as they walk in? Will you do questionnaires of employees to ask them about whether they've been experiencing symptoms? The EEOC has recognized that COVID-19 is a direct threat. Ordinarily, employers may not ask these types of invasive questions or give or take temperatures, but because it's a pandemic, the EEOC has given employers the green light to go ahead and said, you're not violating the Americans with Disabilities Act by asking these questions or by taking employee temperatures, as this virus is a direct threat to the health and safety of both the individual, that employee, and others in the workplace. As we've heard many times, encourage anyone who's sick to stay home. Plan for a situation if the employee gets sick. Make sure that your organization is in touch with state and local authorities and aware of what the situation is in terms of the safety to return to the workplace, and keep your employees updated. Let them know, here's what we're doing and here's why we're doing it. Monitor employee absences and try to maintain flexible leave policies. If there are obviously cases of COVID-19 at your workplace, you're going to notify the local health authorities. And so all of these things are very important. One of the things that the CDC is recommending is that, particularly with employees that are at higher risk for severe illness, to support them through telework options. Consider offering them, those who are higher risk, duties that would minimize their contact with clients if agreed to by the worker. Now we have to be careful, as we will talk later on, about just being mindful of potential discrimination claims where you're dealing with either pregnant employees, you're dealing with older employees who could have potential age discrimination claims. Any actions that you're taking, you want to ensure that you're communicating with that employee about what it is that they, would like to be doing. I think if you're offering them a position, you have to ensure that this is something that, in fact, they want to do for their own health and safety, that they want to be in a lower risk position. So every situation is going to be different, and you're really going to have to look at the facts in that particular situation, and also consider what the legal risks are, which we'll talk about a little bit later. Also, if you have other tenants in your space, you want them to ensure, you want them to know what your rules and protocols are for that space, so that they're also abiding by those rules. And that includes, the use of face coverings or gloves or hand sanitizer, etc. CDC has also said that you could provide employees from higher transmission areas the opportunity to work remotely, to eliminate, the risk of them getting exposed and then transmitting it to others in a lower risk area. So we have a number of poll questions. Our first one today is, I'm interested to hear whether your organization has already set up a task force to address the return to work. So if you would submit your answers, that would be terrific. Then we can all see kind of where everybody is on the spectrum of planning.
We'll give everybody just a few more seconds to submit your answer.
Okay, well, that is terrific. Are the poll responses visible to everybody? Great. So we can see that the majority of the participants today have a plan in place or have a task force that's working on this. So that is really excellent. So just one moment. Okay, so I want to talk to you just about some things for you to be thinking about if you haven't already implemented these things as your task force convenes. And that is thinking about both social distancing and safety and low touch solutions for being in the workplace. So really think about, as your task force walks through your workspace, every aspect, every part of it, every region of it, and what, if anything, do we need to do in this area to mitigate the risk of somebody being infected. So if we have a time clock that people have to punch when they come in, what are we going to be recommending? Are we going to be recommending that people wear gloves? Are we going to find an alternate way of them entering their time to minimize the risk of people touching the same space? Are we able to safely leave our door open to reduce the frequency with which our employees are touching doorknobs or door handles? Is there a way that we can safely do that if we have doors to different rooms or conference rooms or areas? can we safely do that? What does our restroom look like? I mean, how many people can ordinarily go in the restroom? Do we now need to put restrictions up on, we're going to reduce this by 50%. If we have 2 stalls, there can only be 1 person in the restroom at a time. And also thinking about putting up posters in the restroom, reminding people about hygiene and washing their hands with soap for 20 seconds, etc. There's also been reports that the virus can be tracked on people's shoes, can be carried essentially on people's shoes. So what are you doing to mitigate that risk? Is there something that you can have at the entrance and some type of anti-microbial mat or something else that you can do to mitigate that risk? Will you provide wipes at the door, disinfectant wipes that your employees can use on their shoes? I've heard of some employers providing some type of welcome package for employees returning to the workplace, which would essentially consist of, or could consist of, a variety of things that you decide to have. It could be alcohol wipes, it could be gloves, it could be the face coverings, it could be a combination of different things, a carrying case for them to bring things back and forth. You may want to encourage employees in terms of, if you have a kitchen in your office, that you're not going to be using any of those utensils in that kitchen, but employees should be bringing their whatever utensils or mugs from home, and disposable plasticware and plates and things like that. I mean, there's so many different parts of your office to really consider, but these are just some suggestions in different areas. There can be sanitizer foot pumps rather than hand pumps, so you don't have people touching the same hand sanitizer bottle. Motion activated lights, as opposed to, so that it's hands-free. Anything that can be hands-free, to consider that. Whether you as an employer are, I get this question a lot, whether you are required to provide PPE for your employees will depend in part on whether you're essential business, and will also depend in part on what your state or locality has dictated. In some jurisdictions, it is required, and employers must provide it at their own cost. I'm recommending that you are, for the safety of your employees, providing your employees with face coverings at a minimum, and think about gloves. And obviously, if OSHA requires your particular industry to provide certain PPE, then you have to provide it as well. But even above and beyond that, you want your employees to feel that you are keeping them safe, that you're looking out for their safety. And so I would suggest that even if your state is not requiring you to provide mask face coverings, that you do that. I think it's important that you're training your employees on how to properly wear their masks, and that the mask should be covering their nose and mouth, but also you're having conversations with them about that as well. I can tell you in New York, we see people wearing masks in all kinds of ways. Sometimes people are wearing it as a scarf, or they're only covering their mouth. So I think when you're going to have employees in their workspace together, that you want to have a conversation with them about what the proper way is to wear the PPE. And also, you know, you can also have protocols making it the employee's responsibility that when they're in a particular work area, that you expect, whether it's their desk or whether it's they're using some communal equipment, that each employee is responsible for wiping down with disinfecting wipes, that they are responsible for doing that after they've used the equipment, and that employees shouldn't be sharing equipment with one another. They shouldn't be sharing their phones, their desk spaces. Some employers have thought about maybe getting desk blotters that are antimicrobial or things like that. I mean, there are all different kinds of things that you can be doing to help minimize the spread of the virus. So we just talked about this. Training should include when you should use it, when it's necessary, how to put it on and off, and how to properly dispose of it, and providing replacements for people that are using disposable. Physical distancing, that's part of the return to work. Thinking about how you're going to keep 6 feet between employees, and also thinking about your clients and the people that you serve and the people that come into your workplace, and your vendors and your visitors and your guests, and all the social distancing protocols that you put in place. You're going to want to communicate those for the clients, visitors, etc. But first, thinking about your employees and what is your work. Do you need to reconfigure your space so that there is at least 6 feet between employees? Do you need to install plexiglass? I'm sure you've seen lots of employers now are putting up plastic dividers, plexiglass. Consider directional markers in your office and one-way hallways where you have floor decals and tape and signs indicating that one hallway is to be one way and another hallway is to be in another way, employees are to walk in another direction. You can have rules about either prohibitions on handshaking and physical contact or discouraging handshaking, and as I mentioned, a plan for common areas. So we now have a second poll question for you. If you would please answer it. Have you created safety protocols for return to work?
Just a couple more seconds for everybody to get your polls in.
Okay, so 42% have. So great. So you've come to the right place, because we're going to talk a little bit about that. But I will say, you know, even with the time that we have today, there's a lot more that can be said. This is just a little overview, really, on just the areas in which you should be thinking about with respect to reopening and safely reopening. But I recommend that you review the CDC guidance. There's also very specific guidance for particular industries. And so it's important that you look at your specific industry. And if you're a school, or I know we're still awaiting from the CDC guidance, which I think is supposed to come today, for churches and synagogues, religious organizations. So we're still waiting on that. But I will say that there is specific guidance for schools, child care facilities, and other types of industries affecting nonprofits. So you'll want to take a look at the CDC guidance and also OSHA guidance. So meetings, you have meetings with your staff. Try to hold those by video conference. Everyone should not be sitting together around the table unless you are making some revisions to what you're going to do. Either you are removing a chair between 2 people so that there's 6 feet of distance to the extent that you can, or leaving space between the chairs, sitting in alternating chairs, removing chairs from you know, if you're traditional office setting, removing chairs from guest chairs from offices, and removing chairs from conference rooms. Also, to discourage employees from sitting close together. If you have fewer chairs, you know, you can create more of that distance. Everything that I'm telling you about things to think about with your employees and consider with your employees extends to anyone who comes into your workspace. So your clients and the folks that you are servicing directly, vendors, people who come to make deliveries on site. You really want to make sure that you're thinking about how you're going to deal with that. And whether, if you have clients coming in, are you going to be providing face coverings to them? Are you going to be having conversations or something that your notification and communications with your clients. Obviously, you want to let your clients know when you're planning to reopen the workplace. You want to send that communication to let them know we're going to be open the following day, the following weeks, et cetera, or what date you're going to be reopening. But you also want to let them know what safety protocols you've implemented, so that they know what will be expected if they come into your workspace. And will you be, and consider providing to those that come to your workplace, visitors and clients, tissues, hand sanitizer, and waste bins that are no touch. It's a great idea to have postings in the workplace. In fact, some of those you must have, but postings on good hygiene, on your safety protocols, on physical distancing, and the expectation is that people will maintain at least 6 feet of distance between one another, and that your protocol now, when clients are coming in, is that you don't do handshaking, or so that they're aware of that too, that's changed. Have a plan for what you're going to do with deliveries and mail, and how you're going to deal with common areas and restrooms. We talked briefly about daily health checks, thinking about what you're going to do to screen your employees for symptoms of COVID-19. And you have to be mindful that when you do that by law, under the Americans with Disabilities Act, which covers employers with 15 or more employees, and your state and localities may also have their own disability discrimination laws, you must maintain the confidentiality of medical information, and temperatures, taking somebody's temperature is considered a medical exam, so the results of that are considered medical information. So you should not be disclosing the identity of a person who in your workplace who has COVID. You of course want to let employees know if they've been exposed, but you're not disclosing the identity of the person who's infected, and you're not disclosing temperature results except for those who have a need to know. And you might even consider whether you're going to be instead of recording temperatures, that you're going to, as a protocol, just indicate whether or not someone is over, someone's temperature is 100.4 over, or if they're within the safe threshold to be at work. CDC provides some examples of screening methods in their general business guidance, so you could take a look at that. Encourage staff who are sick to stay at home. What I have here is actually New York. In New York, our governor has created a safety plan template that all businesses that are reopening are required in New York to have a safety plan, a written safety plan. They don't have to use the state's template, but the state's template sets out some of these things, and so it's helpful. I think, in just some guidance in figuring out how you're going to go about doing this. So these may be some of the things to think about, asking about symptoms that the person may have had, COVID-19 symptoms in the past 14 days, a positive test in the past 14 days, and or close contact with current confirmed or suspected cases. I would also say that it's important to also stay up with whatever the guidance is on what the symptoms are, because we know this is something that as we get more information, we learn about additional symptoms that may be symptoms of COVID-19. And I'll also say, as you already know, is that even though you may be taking temperatures, we all know that a person can be positive for COVID and not have a fever. So it's certainly possible the person could have COVID without registering for a fever. Make sure that you've got policies for protecting your workers, and provide training to cleaning staff. So what do you do if somebody comes to work with the symptoms? They should be immediately separated from other employees and other individuals. If they develop the symptoms outside of work, they should notify their supervisor and stay home and follow CDC's recommended steps. If somebody's had close contact with a person diagnosed, they stay home and self-monitor and follow the CDC guidance. And if they don't have the symptoms, they follow the guidance for home isolation. So certainly, if you find out, you want to figure out how to safely transport the person, you want to notify local health officials, if they know of a possible case, you do want to let employees know if they may have been exposed now that you know that an employee has tested positive for it. You want to let them know that so that they can go home and self-quarantine for 14 days. You close off an area that's been used by that person, and obviously don't use it until it's been cleaned and disinfected. The CDC discusses the disinfectants and things that can be used to disinfect your workplace. Okay, advises sick staff members not to return until they've met the criteria for discontinuing home isolation. And the CDC is recommending that you implement flexible sick leave policies and flexible policies and practices. And I would echo that too. Kind of one of the larger takeaways here is to be flexible in addressing accommodations and addressing issues to the extent that you can during this time. Monitor absenteeism. Think about whether you need to cross-train employees for essential functions. If you're going to have an employee out or multiple employees out due to COVID-19, you want to be planning now. Are there ways in which I can cross-train certain employees to perform other functions? If people got sick in the workplace and we have certain essential functions that absolutely need to be done, we only have one person that does this. So also designate someone in the workplace that may be somebody from your COVID-19 task force who's going to be responsible to respond to COVID concerns, and let the employees know who that person is. The CDC has talked about that, adhering to their hygiene and sanitation recommendations as well as those of your state's Department of Health. When you're doing cleaning, maintain logs on that. We've already talked about have places for hand sanitizer. Make sure there's soap, and have employees ensure that employees will tell a designated person if you're out of soap or you're out of hand sanitizer, so those can be replenished. And the CDC says it has to be alcohol-based hand sanitizer to be useful in fighting the virus of 60% more of alcohol. Okay, we all know, we've heard many times the safety protocols about washing hands with soap and water for at least 20 seconds, using certain types of hand sanitizer, covering coughs and sneezes with tissue or the inside of your elbow, and staying home when you're sick. As I mentioned briefly, post signs in your workplace on how to stop the spread of COVID. CDC has posters. Your state and local public health authorities should also have posters that you can put up. You cover your cough and things like that. Make sure that you are regularly cleaning and disinfecting, that you know what your cleaning company is doing each day to clean your work area, or as often as it needs to be. And have a plan for what the cleaning is going to be. Consider if somebody tests positive for COVID-19, how are you planning to clean the area? Have you thought about what products you're going to use and how you're going to get them? Plan now for that also, because as we know, it's been difficult sometimes for people to get even Lysol disinfecting wipes. So if you know you're going to be opening in a few weeks, or you're contemplating that, plan now for getting your supplies. We talked about the testing. that the EOC has given the green light now for employers to do temperature testing. I can say that the testing should be, you want to know that the testing, if there's testing that's done, that it's if there is testing at this point, separate and apart from the temperature checks, that it is consistent with current medical knowledge, and that the tests are accurate, and that you're following the test manufacturer's guidelines and instructions. So you also want to think about contact tracing. If you have a very large workforce, how are you going to trace the close contacts? Was the employee interacting with your clients? Which of your clients? Who else came to your workplace that your employee was interacting with? So you want to think about that now. Do we have a method to do that, to track? Or how will we do that? How will we inform close contacts? So also have a communication plan. As I said, have a short kind of sheet that gives employees a sense of, here's what we're planning to do. Now I will say, and I'll tell you later on, you can have a more extensive plan, but give something first to employees that's easy to digest in what your plan is going to be going forward. Think about having a log of people in your workplace who may have close contact with others. Once somebody gets infected, you're going to have a log of who that person interacted with. And make sure that you have contact information for the individual. So if an employee is infected, you're able to communicate quickly with others who may have been exposed. We said, if an employee tests positive for COVID-19, you need to notify immediately the state and local health departments about that and cooperate with the tracing efforts. I talked about having kind of a user-friendly overview for employees on how and when they're coming back, answers to some frequently asked questions, how you're going to keep the workplace safe and clean, health screenings, what your protocols are going to be, being able to answer questions about how people are getting to and from work or when, and how they should be handling interactions with clients and meetings with coworkers, and what to do if somebody contracts it, where they can find your updated paid leave policies and Families First Coronavirus Response Act policies. Now we'll get to the building issue. I'm hopeful that different organizations, real estate organizations in the real estate industry will be issuing their own guidance, that building property managers will be issuing guidance to their tenants on what it is they intend to do. But of course, before you come back to the workplace, you will want to know from your property manager, from your building, if you're a tenant, what is it that you are doing to ensure the safe return of our tenants to the workplace? What are you doing for the common areas? Is there going to be a protocol for elevators if you're an elevator building? How are you going to keep us safe in the common areas? What is going to be the policy about visitors and how many people we can have up at one time? And is there protocol? What are they doing with respect to the HVAC system? We've heard concerns about virus spreading through air conditioning systems. What are they doing? What kind of filtration are they doing? What kind of mitigation are they doing for Legionnaires Disease and mold? We know that systems that have been stagnant for a long time, where the water hasn't been running, like may be the case in many office buildings that have kind of just been on functioning either shut down or functioning at low level. You want to make sure that there's some mitigation for Legionnaires Disease, which is a type of pneumonia that individuals can get. So thinking about all of those things, I would say also think about, take a look at your lease. with your building to see what type of protections you might have in there with respect to the expectation of the landlord in making sure that your space and the common areas of the building are safe. And that includes what's going to happen coming in and out of that building. You know, are you going to have to touch the handle every time you come in and out? Are they modifying it? How are they addressing those types of things? Another aspect to think about, obviously, is staffing. What is this going to mean for your workforce? In terms of, you know, for financial concerns, are you going to furlough employees? Are you going to need to continue to furlough employees? Are you communicating regularly with those employees who are on furlough about what's happening? How are you going to decide which employees come back into the workspace and which ones are working remotely? In terms of mitigating legal risk, you want to make sure that you have neutral criteria for determining that. Are you determining it based on, you know, that the person is working productively, they're performing well from home so they can do that? Or it may be that employees want to come back. So how are you deciding who gets to come back into the office? So you really want to look at what the factors are that you are considering in either allowing people to work remotely or having them come back. And also we hear around the country that some large employers have decided either remote work is something that's going to stay, is here to stay permanently, or they're going to be doing it on a long-term basis, or they've realized they don't need all the space that they had. You know, be thinking about what is our short-term, our mid-term, our long-term plan in terms of where employees are going to work and what we need to do, if anything, in terms of cost-saving measures, either, you know, whether we need to furlough or lay off, whether we're going to reduce some people from full-time to part-time. We talked about staggered start times and staggered days and weeks and things to think about. I heard about a very interesting study that had been done by the Weizmann Institute in Israel and the London School for Economics, where what they proposed, and something to consider, is 4 days in the office, 10 days working remotely. And the reason for that is to kind of match what happens with COVID-19, where the person doesn't show symptoms until after 3 days. So essentially you would be quarantining your employees for those 10 days after they've spent the 4 days in the office, so that in fact, if they had gotten infected, you would be mitigating that risk by having them work from home for 10 days and then come back 4 days. So it is something to think about. Really think about in a planned way how you're going to bring employees back, and be flexible in what the possible solutions are. So what workplace, this is our third and final poll question for you. What workplace legal developments and risks are you most concerned about? Discrimination claims, sexual harassment, wage and hour, safety, health, retaliation claims, Families First Coronavirus Response Act laws or other paid sick and family leave laws, WARN Act violations, cybersecurity, liability, union organizing, National Labor Relations Act issues, increase in unfair labor practice charges, or something else.
Anything else? Go ahead and put that in the chat box. We would love to hear what you're most concerned about in your organization. Just a few more seconds. I know that there's a lot to read through.
Okay, safety, health, and OSHA. Okay. Yes, I can understand that. And so we're going to talk about, related to that, those touch on some other areas as well. Okay. So first I'll talk about discrimination. We will get to safety and health issues. The EEOC, that's the Equal Employment Opportunity Commission, that's a federal agency that enforces Title VII of the Civil Rights Act of 1964, which is a law prohibiting certain types of discrimination in the workplace, race, sex, religion, national origin, color, has noted that during the pandemic, due to the pandemic, there's been an increase in bias against Asians. And I mention this to you so that you are mindful, that your managers are mindful and vigilant to ensure that there are not derogatory, disparaging comments, behavior directed towards Asian employees. This is a good time to consider doing refreshing your EEO trainings, your anti-harassment trainings, your anti-retaliation trainings. And separate and apart from that, it's really important to be thinking about, there are going to be a whole host of potential discrimination issues with respect to so many aspects of what is happening now, whether you've laid off employees, whether you've furloughed them, whether you've reduced their pay, there could be discrimination claims. Because we know that the illness affects that people who are over the age of 65 in particular are particularly vulnerable. You could have potential age discrimination claims in connection with decisions that you make about who to bring back into the office, who not to bring back into the office. There could be what are called disparate impact, where you have a neutral policy or decision that you make, but it has a disproportionately negative impact on a legally protected group, like people over the age of 40, or a particular race or gender. We know also that pregnant women are particularly vulnerable. Well, pregnancy is also a legally protected category. So you really have to be careful and mindful and deliberative in your decision making on any adverse employment actions. There are also questions about reasonable accommodations and sexual harassment. We're going to talk about that. So we just talked about health screening and issues and testing and taking temperatures, the need for confidentiality. That's very important. This touches on questions about people's medical conditions and preventing discrimination against the disabled, since disability discrimination is unlawful under federal, state, and local laws. So how do you mitigate against the discrimination claims? Make sure that you have legitimate non-discriminatory reasons for the decisions that you're making, whether it's decisions on who gets to work remotely or who comes back to the office, who you're recalling. Ensure compliance with EEOC guidance, Americans with Disabilities Act, that's the ADA, and state and local anti-discrimination laws. We'll talk about sexual harassment. So sexual harassment, some folks may think, well, we're not in the workplace, so how can there be sexual harassment? Well, there can. I mean, we've heard stories of people coming to Zoom calls and they say, they're not wearing any pants, so put your pants on and when you come to your Zoom call, come to work because you're still at work. So I think what has happened and how these claims might arise in the remote workplace is that employees have gotten more casual because we're working from home. And so that may cause individuals to have the mistaken belief that they can be a little bit looser in terms of how they interact with their coworkers. The other thing actually is that because we are working remotely, this type of behavior and these incidences are more difficult to monitor, for managers to kind of have a handle on, or information about, let's say. There might be a feeling of a lack of accountability and difficulty monitoring the behavior. So a few years ago, the EEOC convened a task force where they studied harassment in the workplace, and they looked at what kind of workplaces bring about higher numbers of claims. And they came up with a whole bunch of different categories where they saw that there were increased risks of sexual harassment. And one of those was a decentralized workplace, or isolated or remote workplaces, or workplaces where alcohol is permitted. Those were 3 high-risk types of workplaces. And so we are in the ultimate decentralized workplace when we're working remotely, right? We are in the remote workplace. So this presents a high risk. And why? Because the manager doesn't always see what's going on. So people are emailing or texting, or they're more casual in terms of what they're wearing, or how they're behaving, or sometimes maybe they're having a happy hour where they're having alcohol at work. So even though they're in their home. So all of these things represent recognized risk factors. So how do you mitigate those? Make sure that you're doing the training, even though your employees are working remotely, that you're re-upping your anti-harassment training, that you're focusing on the risks of sexual harassment in the remote workplace, that you're setting, again, just reminding your employees of what your expectations are in the workplace, even though they're working from home. And it's really important with the managers, that to emphasize that, and to make sure the employees know, remind them of what the complaint mechanism is in the course of your training, to report any type of behavior that's making them uncomfortable. And make sure that your policies address behavior that could happen in the remote workplace, and that employees have an opportunity to connect with one another. Now, on the issue of reasonable accommodations, how does that come up? Well, you may have employees who have a medical condition or who are pregnant, who say that they want to have a reasonable accommodation, which could involve continuing to work from home. And employers have a legal obligation under the Americans with Disabilities Act to engage in an interactive good faith process with their employees to determine a reasonable accommodation. And some states and localities have even higher requirements in terms of what an employer needs to do to engage in an interactive process. So look to your state and local laws in terms of what the level of duty is that you have when someone presents to you that they need an accommodation, even if they don't use the word reasonable accommodation. If they need some modification to a schedule, or they want to be working remotely or something to that effect. So the types of claims you could have are a failure to reasonably accommodate a person who you're legally required to accommodate. There could be potentially in jurisdictions where a perceived disability is a legally protected category. You could have potentially a discrimination claim, where somebody says, I wasn't allowed to return because they thought I had a disability, but I didn't really have it. In jurisdictions where caregivers are protected, there could be a claim by a caregiver that they're being treated less favorably because they have caregiving obligations. And of course, one of the most important things as an employer for you to know in all of these respects is to make sure that your managers are trained on your policy that prohibits retaliation, because retaliation is prohibited for complaining about discrimination, for complaining about unpaid wages, for complaining about safety issues. So you could also have a situation where you have existing employees who have current medical conditions, or who have, you could have someone who's low sight, you could have someone who's deaf, and you need to think about, how am I going to accommodate those individuals when we make workplace reconfigurations? If we are expecting physical distancing and we have markers on the floor, what are we going to do to ensure that those employees are taken care of too? We have a deaf employee who lip reads, okay? The masks we're providing aren't transparent. What are we going to do to accommodate that person? So it's important to be thinking about those things. It's important to be thinking about underlying conditions and whether accommodations need to be made, as well as whether a certain mental, psychological conditions, anxiety, depression, etc., may warrant a reasonable accommodation. So to mitigate these types of risks, follow the guidance that's put out by your anti-discrimination, the agencies that enforce these laws, at the EEOC and your state and local agencies. Be flexible in arriving at accommodations. Document the process that you did to engage in a cooperative dialogue. And if you're unable to provide the reasonable accommodation, you are going to want to document why you didn't provide it and how it was an undue hardship, meeting whatever the standards are in your locality for showing an undue hardship. We know that, I think lots of jurisdictions right now are kind of working through what it is that they need to be doing. This slide happens to be guidance that was issued in New York City by the New York City Commission on Human Rights, who is still in the process of, I think, working through clarifying their guidance. But this is their guidance currently around COVID and employers' obligations. So we are still looking for some clarification, and they are planning to issue something hopefully in the next few weeks to provide clarification. But I think that a lot of agencies are grappling with the parameters of providing reasonable accommodations during the pandemic. And so you should continue to stay abreast of all of those developments at the state and local level, in addition to any additional guidance that the EEOC will be issuing. So one of the questions that I get often is a question of, well, what if my employee refuses to return to work? Now, the answer to that question is a lawyer's answer, which is it depends, but it really does depend on what the situation is, what the facts are. If the reason that they're refusing to return to work is because of an underlying condition, you may need to consider, what do I need to do? Do I need to reasonably accommodate them? I've heard, situations people say they're not returning to work because they're making more on unemployment insurance now with the additional $600 a week. That ends July 31st, as far as we know. And in most places, they have to be ready, willing, and able to return to work. So that's an important consideration. But there's also the question of, you have an employee who says, a generalized fear of coming back to work is not typically going to be a legal justification not to come back to work. But I say there's a caveat, which is, if the employee says that this workplace isn't safe, I've got concerns about unsafe conditions. We heard about the situation with the Amazon workers doing a sick out. They said the conditions at the warehouse, I don't think that they're, I don't think those conditions are safe. Or we hear in the news these employees leaving and saying, we think this is an unsafe condition. Well, then you may have a situation here, right? You may have a situation where if you are not complying with OSHA's guidance, if you are not complying with CDC's guidance, then you are putting yourself at risk, potentially. You also are, what I have here is, under the National Labor Relations Act, which some people think only applies to unionized workforces. It does not. It also applies to non-union workforces. And your employees, if you're a non-union workforce, have the right to complain about unsafe conditions. And if they're if they're engaged in what's called concerted activity, which is typically 2 or more people, but there can be situations where the person is acting on behalf of themselves and others, then they're speaking out. They are engaging in legally protected activity and cannot be retaliated against for doing that. Where you may be dealing with unsafe conditions, or where a person is complaining about their wages and saying, we think we should be getting we should all be getting hazard pay, and a group of them say we should all be getting, they're complaining about a term and condition of their employment, and their concerted activities may be protected activity under the National Labor Relations Act. So that is something to be alerted to. And how do you mitigate risk? You mitigate risk in those situations by, number one, following the CDC and the OSHA guidance to ensure that you are providing a safe workplace to your employees. To provide a mechanism in your workplace, an effective mechanism for employees to raise safety and health concerns, and to have a point person or point people who are going to address those concerns. You should document all efforts that you make to address safety and health concerns. So those are some of the things. So yeah. So I'm getting ahead of myself here. Okay, so we talked about the National Labor Relations Act and the risks of claims under that law. Retaliation is prohibited. Retaliation against an employee for participating in a sick out, that could be also protected by the NLRA. If you have 2 or more workers who filed an OSHA complaint together, jointly complain, that could also be considered engaging in concerted activity. So you really do need to be mindful of those things. I want to tell you on this call that I think probably one of the greatest risks that you may face now as an employer in a non-union workplace is the risk of union organizing. We know that unions generally have been unionized workforces have been on the decline in the United States. However, that is changing, and that is changing rapidly. I think in part, you have lots of people who are unemployed right now. The unions do not have the dues, right, for their organizations because many of their members may be unemployed currently. So they are certainly looking to increase their ranks. And at the same time, safety and health issues are some of the primary issues that workers rally around, or that unions rally around, when energizing and mobilizing workers to join unions. Safety and health issues. And you will hear it in the news, and you will see it. You will read stories about employees being approached by unions. So this is something to be very mindful of. And the way to address that is to ensure that you have real effective mechanisms to address safety and health concerns. Because if you are addressing those concerns, and employees will not feel the need to necessarily to go externally to seek union representation. It's kind of a similar thing I say with discrimination claims. How do you mitigate the risk of that? You provide an effective complaint mechanism for employees internally to complain, so that they don't feel the need to have to go to the EEOC or another agency. For those workplaces that have unions, I expect to see an increase in unfair labor practice charges, issues around retaliation. There could be whistleblower laws at issue. So OSHA, the Occupational Safety and Health Administration, under that law, employers have a general duty to provide a workplace free from recognized hazards that are causing or likely to cause death or serious physical harm to employees. And it prohibits employers from retaliating against employees for exercising their rights, and including complaining about health and safety. Now, employees don't have a private right of action under OSHA, but the Secretary of Labor can bring an action on their behalf. And often these come up as OSHA retaliation claims. It could also form the basis of a state whistleblower action. And some states, like New York and New Jersey, have limited whistleblower laws. New Jersey is broader than New York's. So for those of you which it look like that seems to be the biggest concern here at OSHA claims, and safety and health, and I think you should couple with that National Labor Relations Act claims, because those things may end up going hand in hand. Follow the guidance about how to keep your workplace safe. Document the steps you're taking to keep it safe. Have an effective mechanism for employees to address their concerns, and that's really crucial. And I'm sure you've all heard a lot about the Families First Coronavirus Response Act. So I'm not going to spend that much time on it, but you will have my slides at the end, and I go into a little bit more detail about what the law provides. At this point, it's just, you know, what are the potential risks. The law is in effect till the end of this year, December 31st. So there's that narrow window. But the types of claims that could arise in that area are where an employer fails to give the appropriate leave under the act, or if you're fewer than 50 employees, but you misuse that exception. And that exception only applies where to providing paid family leave or providing paid sick leave that is for an employee who's unable to get their child care is closed or their school is closed. It's only in that limited situation. It doesn't apply to paid sick leave for other reasons. But if an employer misuses that, or that could be a potential issue where they didn't give the leave that they were supposed to give, or an improper application of the Families First Coronavirus Response Act in conjunction with other state and local paid sick leave laws. So it's really important that you understand what those are, and the damages can be severe, liquidated damages, which are double damages, attorney's fees and costs, or even loss of the payroll tax credit where an employer didn't provide leave but should have provided leave. So it's important that you're aware of your local laws and the interplay between them. Other potential types of workplace legal claims are wage and hour claims, of course, off the clock work that may happen with remote work, right? If you have non-exempt employees, you need to set parameters around when you're expecting them to work, have timekeeping systems in place so that you know when they're working. They shouldn't be responding to emails or texts or reading emails and texts during what we say off the clock hours that they're not scheduled to work. You want to make sure you're documenting they're taking the breaks that they by law need to be taking, if any. Meal breaks, and I know in California there are additional breaks. So you want to just make sure that all that is documented and that you have a timekeeping and attendance system. There's some question about whether the time that is spent on employee temperature taking if you have a large work staff and you've got people waiting online to get their temperature taken before they enter the workplace, whether that's compensable. It may be in some jurisdictions, so you want to be alert to that. And you know, just issues around when people complain about wages, that's protected activity. So they can't be fired because they complained about their wages. So that's important to be aware of those types of claims. And you might also have state wage and hour types of issues around remote work. There could be issues around, so we talked about retaliation claims. There could be issues around you're misclassifying the employee. I know a lot of employers for cost-cutting measures are doing different things like reducing pay, and the way in which that you do that and maintaining salary thresholds for someone who's exempt is really, really crucial. So I know I'm talking really quickly. We still have some ground to cover, so I'm going to speak very quickly, but you will all have time for questions, and on Tuesday I will answer everything that you have questions about, because I know it's a lot of information. Just a real quick thing, cybersecurity risks. Obviously, you've hopefully put some things into place so far, because so many of you are in states with stay-at-home orders where all of your employees, or many of them, are working remotely. If you haven't already seen this, and I can tell you I've experienced firsthand, there is an increase in phishing scams where people are sending out emails, fake emails from an address that looks like someone that you know at work, but it turns out it's not. And so you have to be really vigilant about that. Make sure that you are sending out reminders to your employees about your policies on not clicking links that they don't know, not clicking on attachments. Be aware there is increased hacker activity. You want to make sure that employees are, using secure Wi-Fi networks, that you have a secure a VPN, virtual private network for your employees, of course. You want to also be thinking about, for those employees who are remote, what is going to be your system if you had to terminate or lay off that employee, how are you going to get your equipment back? Do you have confidential data that they have now in their home? So putting in place plans and protocols and even agreements with employees to ensure return of property. There are risks with employees transferring organization data to their personal email accounts. So you really want to make sure that you've got data security policies addressing these types of things, as well as remote work policies, remote work agreements. Unsecure connections to organizational systems. As I mentioned, you want to have a VPN. You want to make sure that employees are not using personal cloud services to put your organizational documents on. If you're using third-party vendors, you want to make sure that how are these going to be impacted, these services, when your employees are working from home. Do the home computers have critical security patch management? Do your employees, the systems that they're working on, are those going to be secure? So what can you do? You can remind employees of your policy, make sure that you have policies addressing this, remind your employees about suspicious activity, about not clicking on links. You know, those should be part of your policies. Review your vendor contracts to make sure you know what your rights and remedies are, and find out from them, what are you doing to keep our data safe? Because your vendors may be working remotely too. What are they doing to keep your data safe? Make sure that your employees have secure home Wi-Fi networks with robust passwords, that their work that they're doing is only on, you know, computers that you've issued, or you're using a VPN, or both. You know, make sure that they're not sending sensitive, highly confidential emails or documents to their personal accounts. Make sure you've got a document retention and destruction policy, and they know about that. Training is key. Training is really key. And also make sure that they are working in an area of their home that is not, all of your confidential stuff isn't out in the open, that they have a designated area where they're working, where they can put things either into a drawer or locked away. We talked about some of the staffing issues, wage and hour agreements, also wage and hour issues, and also if you have employment agreements with certain employees, you want to be mindful of what those are when you are looking to terminate an employee, and whether you are going to need to pay out under the contract. If you're subject to a collective bargaining agreement, what are the obligations with respect to you know, layoff and recall, et cetera? What's going to be the impact of a furlough with respect to your health insurance benefits? Are those going to be able to continue? If so, for how long? Those are important issues. So consistency, documenting the process as to how you decide who you're furloughing and laying off, what the reasons are. I would say the same is true if you're reducing salary or changing status of an employee. You've got to make sure that you are not inadvertently converting an exempt employee to a non-exempt employee because of the way in which you are reducing their pay, or because they've fallen below the salary threshold. And make sure you're complying not only with the federal wage and hour laws, the Fair Labor Standards Act, but also state wage hour laws. Confer with your health insurance company about keeping employees who are furloughed on health insurance, about what your health insurance company allows with respect to that now that the employee is not working. So here's just some mitigation suggestions in terms of meeting salary thresholds, complying, making sure. Oh, this is another important thing. So as you may lay off staff and you have a leaner, or you have a smaller workforce, right? You may have some employees doing more work than they did before. So if you have an exempt employee, you want to make sure that if that person's wearing multiple hats, that they are still going to qualify as exempt based on what their duties are. Because to be exempt, they have to meet a certain salary threshold in the state, but they also have to be performing certain duties to qualify for that. So you don't want a situation where they end up performing more non-exempt duties and they are converted to a non-exempt employee. It's important that you're mindful of that. Document decisions for the reasons that you the reasons that you decide, again, to lay someone off, to furlough them. We've talked about the issue of, employees maybe not wanting to come back to work. We know that that additional money is ending in July. So, that there is a hard deadline to that. But in addition to that, as I said, employees generally have to be ready, willing, and able to work. As an employer, you can certainly invoke that if depending on what your state's requirements are. We talked about OSHA claim. We talked about what I see as increases in union organizing activity. I'm going to kind of breeze through these slides on the Families First Act. I will certainly answer any questions that you have about it, but I think that I've addressed some of the legal risks in connection with that. And just because we are short on time, I want to get to some of the other things that we've talked about. We've talked about with the Families First Coronavirus Response Act that you want to make sure you're providing the paid leave under that law and doing in the correct amounts. That if you are invoking a small business exception, that you are documenting that. You're documenting the basis for that because the law requires that. It requires that you set out certain criteria that would show as to why you it would, providing the leave would jeopardize the ongoing viability of your business. So we talked about, inadvertent reclassification from exempt to non-exempt. We talked about off-the-clock work and overtime. Obviously. So the other issue is on off-the-clock work is that if you have employees that are answering emails and responding to emails during non-work hours, you could have a situation where your employee is entitled to overtime pay, and so a way to prevent that from happening, having overtime pay where you didn't realize the person was working overtime, is to ensure you know what hours they're working and that you have policies that prohibit for non-exempt employees, prohibit them from working outside their schedule. There are also notice and record keeping requirements. You should be aware of what your state may require in terms of providing a notice of pay rate if you do change your employees' pay rate, if you're reducing their pay. So you need to know what your state requires with respect to notifying, if anything, with respect to notifying your employees of a change in pay. We talked about we've talked about a breach of employment contract. We talked about OSHA and the potential for those claims and potential retaliation claims. To the extent your state or locality issue particular guidance during the pandemic that you don't adhere to, those are obviously potential legal risks. But there's also something called WARN Act, which I just want to alert you to if you haven't heard about it. There's both a federal WARN Act and certain states have what are called mini WARN Acts, which are different notification requirements. The federal WARN Act, the Worker Adjustment and Retraining Notification Act, requires employers of 100 and more employees to provide 60 days notice to affected employees and also certain representatives and local government officials where there is what they define as a plant closing or a mass layoff that results in employment loss to a specified number of employees. The penalties for not providing that notice or for providing an incorrect notice that doesn't contain all of the elements that it's required to contain, or it's not sent to the right people, etc. You can be liable for up to 60 days of pay and benefits, plus civil penalties and attorney's fees. The state mini warns may be more, may require even more notice, like New York requires 90 days notice. But here, this is the federal law. So just be aware that if you are of a certain size and you are laying off a certain number of folks, plant closing under the federal warn is the closing a facility that affects at least 50 full-time employees, but there are other variations of that. it could be a layoff of 500 or more at a single site during a 30-day period, or layoffs of 50 to 499 employees, where that's 33% of the active workforce. So the laws are very particular in terms of when a WARN Act notice is required. And so if you are looking to lay off a certain number of employees, it's very important that you find out, number one, whether your state has a mini WARN Act, and if so, how much notice you need to give, who you need to give that notice to, because you could face serious penalties. Now, the laws do have these unforeseen business circumstances, and that's of course something that has come up. Obviously, with the COVID situation, we've had that in New York, and I've had that with clients where they simply couldn't give in New York 90 days notice because we didn't have 90 days notice. We were told to shut down. But nonetheless, in an exercise of caution, the clients have issued these WARN notices, even though the circumstances were unforeseen, so that their employees have notice, and so they're not subject to the fines and penalties that could be imposed under the state. So that's just something to be aware of. Know what the events are that trigger the notification, and be alert to whether your state law has its own mini WARN. There may be states that have suspended their WARN acts, so that's also something to find out about as well. Okay, we talked about a violation of collective bargaining agreement. It may be possible that if you are implementing new safety or other health terms, that there may be certain things that you may need to, that may be the subject of collective bargaining. So that's something to be alert to. Could there be gross negligence claims? I mean, one of the questions that keeps coming up for organizations, of course, is, well, can we be liable if one of our employees gets sick, gets COVID at the workplace? Most times, many times, your negligence claims will be covered by workers' compensation. Each state has a different standard of whether or not what workers' compensation would cover a claim, what they consider to be arising out of or relating to the workplace, or what is a covered workers' comp claim. I would say, really, just to minimize the risk of a gross negligence claim, even if a negligence claim were to be covered by workers' comp, one of the best ways to mitigate those types of claims is to show that you followed the guidance, to document that you followed the guidance. Engaging volunteers. You're thinking about engaging volunteers, right? Bringing them back. How are you going to do that? You need to think about, just like you did with your employees, how are we going to do that safely, right? Do we need to do staggered shifts? What does the state allow us to bring back? How many people? Is it safe for us to do that anyway? Are we going to be providing mask coverings? I mean, face coverings, masks, and gloves to our volunteers. You really, I would say, to think about them in a similar way as you would to, even though they're not employees. I mean, in some states they have the same protections as employees, but how are we going to protect those volunteers who are working on our behalf? And they need to be trained in all of our protocols. If we have volunteers conduct health screenings just as we would for our employees, make sure we have contact information for our volunteers, and that they're not here and then gone, because if one of them gets infected, then we're going to have to do contact tracing. Will our insurance cover a claim by a volunteer or a claim against a volunteer? Do we have volunteer waivers of liability? Think about that. Having those and using contact tracing when you can, providing the same types of soap, hand sanitizers, etc., and implementing physical distancing protocols. There's certain laws that say that volunteers will not be personally liable for their acts or omissions so long as it's not gross negligence. We're hearing the CARE Act provides immunity for certain, healthcare volunteers. Some states like New York, Illinois are providing civil immunity for healthcare facilities, providers, and volunteers who are doing the work. But I know your question is, well, what about a volunteer suing us, I say, think about having waivers of liability. What about business immunity for workplace COVID-19 cases? We don't have it, generally speaking, as I said, but there is a proposed bill in Congress to provide immunity to employers that's proposed right now. So just to wrap up on some things to think about, to reiterate some of the things that I've said, implement the plans along the lines that we've talked about, the different types of plans that we've talked about. Think about also, what if there is a second or third wave? What can we implement now to safeguard ourselves or to have something going forward? Think about short-term, mid-term, and long-term plans for each of these different types of things, for physical distancing, for cleaning and disinfecting. Are we prepared if we have a second wave to retract? Are we in a position to be able to do that? Put plans in place for each of the categories that I have talked about. Really crucial, your communications, particularly with so many remote employees, should be more frequent and regular, keeping in touch with your employees, letting them know what your plans are, what are going to be the safety and hygiene protocols when you go back to the workplace, how's return to work going to happen, what are going to be the new protocols, how are we going to interact with clients and the people that we serve and volunteers. So communication is key with your staff, regular communication about this. Talk to them about, and your clients, talk to your clients about what your schedule is for returning to work, how your clients are going to be serviced, and what kinds of things can still be done remotely. Implement policies along the lines that I've talked about, remote work policies, your attendance timekeeping, the safety and hygiene, cleaning and disinfecting and health screening, physical distancing, all the things I've talked about. You want to think about having policies in place to address those. Restrictions on business travel, the expectation for interactions in the workplace with vendors, visitors, and clients. Update your EEO policies, make sure sexual harassment addresses the remote situation. Update your paid leave policies to address the current paid leave that you have under the FFCRA. Make sure your data security policies protect what you need to. Employment agreements for remote work, and data security, and how to address also employees who are working remote who then get terminated and you need to get your equipment back. Enhance training on wage and hour compliance. It's time to do your sexual harassment training again and the anti-discrimination training, and training on the protocols on how to use the PPE. Cross-training employees, we talked about that. Your expectations for employees, whether they're working remotely or not, in the new normal, what you're expecting. Follow the guidance, update your job descriptions where employees are performing additional functions, determine whether workers' comp or other types of insurance would cover claims, what's your coverage for business interruption, for COVID exposure at your events, if you're planning to hold events, and what do your vendor and event contract agreements say to ensure coverage for pandemic-related events, particularly if we're to have another wave. Clear complaint mechanism for safety concerns. Train your managers on ensuring there's no retaliation. Document. I think that's self-explanatory. It's really important that you document your efforts in all these different areas to mitigate legal risk. And be consistent in the application of your policies to employees to reflect fairness and a lack of bias. Postings, make sure you have the proper postings, FFCRA posting and OSHA and other anti-discrimination postings, your hygiene and safety postings with respect to COVID-19. Think about if you can continue working remotely, the extent to which you can do that. Be flexible in your work arrangements. Stay in touch with your legal counsel because the laws continue to change, the guidance continues to change and evolve. Know about the federal, state, and local laws and how they overlap, the interplay between them. Talk with Employee Benefits Council on how what's happening now may affect your benefit plans, and if you have employees on visas, speak with Immigration Counsel about the impact of any employment actions on that. You need to know in your particular state what the law is there with respect to administration of unemployment insurance benefits. See if your state and local paid sick leave laws may interact, and also any mini Family Medical Leave Act laws and state mini warrant laws. And then just a final note, think about if there are new ways to service your clients. In the medical space, we hear of telemedicine. Think about, are there new ways in which you can provide your services that maybe you never used before? This presents an opportunity for us to do things better, to do it differently, but to do things better too. So think about that, and also if there's cost containment, cost cutting measures that need to be made going forward. Communicate regularly with your staff, how you can support them. Just finally, I don't want to overlook, it's really important. People are going through so much right now, not just financially, but emotionally, and make sure that your employees know about any EAP programs you have, whatever mental health resources you can provide to them, and think about other ways you might be able to support them, your employees and their family, emotionally, financially, and otherwise at this time. Organizations are doing amazing things to support their workers, whether it's financial things that they're doing, whether it's providing different types of wellness services, meditation and yoga, paid childcare, all different kinds of things. So think about those things as well, the whole, the well-being of your employee, which brings, loyalty, that your employees know that you're caring about them, and doing things to keep them safe during this time. So thank you very much for your time and attention. I know we did go over, and I thank you very much for your time and attention today.
Yes, well, thank you so much for all of your expertise, Lisa. This is so wonderful. Thank you all for joining us. Yes, the slides will be sent to everybody along with the recording of today's webinar. If you have any questions, please feel free to throw them in the Q&A section at the bottom of your screen. We will get those all answered for you on our webinar on Tuesday. So we'll see you all back here in a couple days. I hope you have a wonderful weekend. And Melody, Lisa, do either of you have anything else to add?
No, that's it. Thank you very much. My contact information is at the end of this, at the end of the slides, and you'll all get a copy of those as well. So thank you very much. I wish everyone a wonderful and safe Memorial Day weekend.
Awesome. Thank you. Thank you all for attending again, and thank you so much, ladies.
Thank you. Thank you, Emily, and thank you, Melody, and thank you, Wegner CPAs.
Yes. Bye.
Bye.